and I hope you're having a good time. My name is Mahdi Baidinejad. I'm the International Officer at the Human Rights Institute, University of Isfahan. We are really pleased to have you here, and I'm personally very happy that you accepted our invitation to join this interview because we all know that we are in a very hectic situation right now in terms of war and conflict. Both Lebanon and Iran are suffering and witnessing a huge damages to the humanitarian infrastructures, to human rights, and other humanitarian related aspects. And I'm also very sorry for your losses of your friends or relatives back to Lebanon, and I hope you can recover it very soon. So I'm really appreciating your presence here. It really means a lot to us. Let me just introduce yourself to our audiences because we're going to publish and put the interview online in our YouTube channel. Bernadette Zaydan is a human rights advocate and a legal professional known for her work on international justice, accountability, and the protection of fundamental rights, especially in conflict-affected contexts. I want to start first with the broader legal aspect. So from a legal perspective, how should we assess the legality of the US-Israeli war against both Iran and Lebanon, and the use of force against these two countries that I mentioned?
Oh, thank you. That's a really important question to start off with. And thank you for including Lebanon. Look, to assess the lawfulness of the US and Israeli strikes on Iran and Lebanon to some extent, we really have to look at the evidence, and we have to look at the history of the parties, because the parties have been essentially at war for quite a while. We know that Iran has been sanctioned by the United States for decades. So the evidence that I'm talking about, to answer your question, is really about Israel launching the first strike on Tehran, and when it launched it on the weekend. It launched it during Ramadan, the fasting month. But as you have pointed out, if we look at the law, essentially Article 2 of the United Nations Charter, all its members must refrain from using force against another country. And there are two exceptions. The first one is self-defense, and this is really important in the context of what's going on. So self-defense is under Article 51 of the UN Charter, and it says that people, individuals, as well as the state, has a right to self-defense. But the caveat to that is it's only allowed to defend itself if there was an armed attack against it. And the second exception is it's in Chapter 7, where the Security Council will authorize for you to defend yourself. So we saw that neither the US or Israel invoked Article 21, and no credible evidence was put to the people, let alone to other governments, that there was an armed attack by Iran against the US or Israel. We heard a lot of rhetoric, and one of the things that we heard is that it was a preemptive strike on Iran, and there is no lawfulness to a preemptive strike. You can't just strike a country. That is not self-defense under Article 51. But then we heard that the rhetoric that Iran is sponsoring and supporting terrorists, being Hezbollah in Iraq and Lebanon. And so that became an excuse for a preemptive strike. But again, that is not, the law does not permit that. And I also want to raise something really important about using the excuse of resistance groups. Now, these groups are not state actors, so Iran cannot be responsible for these groups. Their actions are their actions. Under international law, there is a right of people to self-determination and self-defense. Now, arguably, that's where the resistance groups fall into that category. The US and the United States have used all sorts of excuses to try and strike Iran. They've used the excuses of its missiles. So these are things that have come out of, the playbook of the US going to war with Iraq, weapons of mass destruction. We have heard the same excuses over and over again. But those political justifications, they can amount to war crimes. So we lawyers need to take a really careful look at these political justifications, because they are not excusable.
And do you see the recent actions in Iran and Lebanon as part of a broader trend toward expanding the doctrine of self-defense beyond its traditionally accepted limits? Do you see these trends right now?
I don't. What I see happening in Iran and in Lebanon, I see what you mean in terms of one side is trying to broaden the definition of self-defense to include things like Iran poses an imminent threat, and Iran may have a nuclear bomb by a set date. That's not how the law works, and you can't broaden a doctrine to include acts that are unlawful under international law. And what the US and Israel are doing is they are taking part in action that is prohibited under international law. And potentially what they're doing is war crimes, and this evidence would be reviewed and should be reviewed by lawyers. And I know what's going on in Lebanon. People call it ethnic cleansing, and there's all sorts of categorization of Israel's actions. But I would go one step further, and I've had a look at the evidence over the past few years, and I would say that there's genocidal intent in Lebanon, and self-defense falls away. No, you can't even bring up the self-defense argument when there is accusation that Israel is committing genocide. And those tweets are really powerful. Those tweets serve as evidence. And that's one of the reasons why I brought up genocidal intent. It's what they're saying and what they're doing. So what they're saying is followed by what they're doing. And so these acts are deliberate, and they are inflicting conditions of life, which is to bring about a group physical destruction. And we know in South Lebanon, there is a lot of destruction. Some people just cannot return to their homes. We know that white phosphorus has been used. We know that more than 1.2 million Lebanese are displaced. We know that the schools, the churches, the mosques, they have all been targeted, and it's all deliberate. So look, their tweets may seem very silly, and it may be causing uproar, or it may be manipulating the markets in the United States. But ultimately, these are really powerful pieces of evidence.
We are witnessing that political leaders inside the United States and Israel publicly threat that they are going to attack these facilities. So my question is, when political leaders openly threaten to target bridges, power plants, whatever you call it, does that in itself raise legal concerns under international humanitarian law even before such attacks even occur?
Absolutely, yeah. Look, from the outset, let's be clear, all civilian infrastructure is vulnerable in time of war. When we, they're essential services that we require for our survival, especially water. And things like, power grids, bridges, schools, water systems, places of worship, they're all protected under law. We know that Article 48 and Article 51 of the additional protocols to the Geneva Conventions, they protect civilian infrastructure. But unfortunately, what we are seeing is they are very much targeted by the United States. It's part of their strategy, and Israel. And we saw that in Gaza. We actually saw this in Iraq as well. We saw the waterways was always a target. So not only does the law prohibit the targeting and the destruction of the infrastructure, but it also does not accept and prohibits threats of violence. Because what that does, it spreads terror among the people, among the civilian population. And what it does, it displaces people. A lot of people, let's say South Lebanon, for example, Israel was quite strategic. What it's done is it's targeted farmlands, very fertile land, which is in South Lebanon and the Bekaa Valley. Those two areas of Lebanon supply a lot of the food that feed the people. And that land, especially parts of South Lebanon, you cannot grow anything, because my understanding is there's been all sorts of chemical sprays, there's been all sorts of, white phosphorus, potentially landmines. So that's quite strategic. So what we have here is terrorizing of a civilian population.
One of the main arguments that the aggressors put forward is the concept of dual-use military target. So they claim that we are attacking this particular space or area because it has a dual-use function. How should lawyers critically evaluate claims that infrastructures in Lebanon and Iran constitute a legitimate dual-use military target?
So by now we have seen, lawyers and non-lawyers, we have seen the pattern, and we have seen the language, the rhetoric, and, like preemptive strikes, dual use, all of that in the context of law, of war is not, it's political. So there is no justification, because what you are doing is you are, at the end of the day, harming and bringing punishment to the civilians. Like I said, you have civilians who can't return back to their land. Forget about their homes, they don't have homes. We have heard time and time again that Al-Shifa Hospital was Hamas. Hamas had weapons there. We've heard the same rhetoric, dual use, about hospitals in Lebanon. We hear the same language, the same pattern over and over again. What I also hear from Israel is that, but there's potential use. Just like they say, the children will potentially grow up to become terrorists. We also have to look at, has this alleged dual use assessment caused loss of water, electricity, oxygen in hospitals, and was it excessive?
I completely agree, and I may add to that the fact that some states like the United States and Israel breach international law very publicly, very vividly. It would lead to the violation of international law by other states as well. So other states would see the pattern, would observe the limitation of international law, would see that only power works, as they say, and they would also start to breach international law based on their national interests or whatever they want. So that's a very dangerous pattern, I would say, and it needs a lot of responsibility by sovereign states to step up and to claim for international law, to advocate international law, to encourage one another to obey and comply with international law.
Yeah, look, enforceability is a huge problem. And in my lifetime, I've witnessed many genocides, and we should not be witnessing genocides. Genocide should not be occurring. We have laws that prevent it. We have laws that require member states to prevent and to take proactive measures to stop genocides. It just isn't working. And there needs to be a review of enforceability. In Lebanon, for example, we have UNIFIL, which is part of the United Nations, that used to go there and be peacekeepers, you know, so-called peacekeepers. But if you speak to the Lebanese, they tell you they're not peacekeepers. They are there to serve the interests of the United States, which has veto power. So all of that needs to be reviewed, and there needs to be a balance. And quite frankly, these are really hard times, but we also, as lawyers around the world, we all need to try and use this as an opportunity to bring about tangible change, to bring about reform in enforcement mechanisms. At the moment, you have the International Criminal Court, where the United States can sanction individuals, and things aren't working. And if we are serious about international law, then we have to reform it.
So how should the principle of proportionality be applied when multiple attacks taken together produce sustained humanitarian harm?
I think by now the United States and Israel have made it clear that they do not conduct proportionality assessments. They simply proceed with the kill. The fact that they bombed a school in Iran, knowing that there are children in the school, the fact that they waged a war on a nation of Muslims when they're fasting in the holy month of Ramadan, they have no regard for that principle of proportionality whatsoever. I do not personally and legally, I do not see that they consider whether their acts will, how many civilians will die. They don't care. They just simply don't care. And we know that. They even bombed a synagogue in Iran. And the issue about the actions taken by Israel and the United States, these actions are deliberate. They target infrastructure, schools, synagogues, while people are in those buildings, when they know they are going to harm and you know, not just destroy the building, but they are going to kill kids in that building, in that school. So there's no proportionality. And I do want to point out that this was also an important issue that the South African lawyers raised in the genocide case against Israel before the International Court of Justice. And I have no doubt, if lawyers bring action against Israel and America for the actions, for the war that they've conducted against Iran and Lebanon, that proportionality will be quite an important principle. And what we saw in Gaza, we are seeing now in South Lebanon. What we saw is, you know, the drones, they just terrorize people. But more worryingly is the drones are used to, the drones are used to kill. And we talk about targeted, we talk about how people are just trying to escape, or they're trying to leave an area. They get evacuation notice, they try, but the drones are already out there. There is no room to move. And then sometimes those drones, what they're doing is there are accounts where someone's crying out for help, and so medics will go to assist, and they end up being targeted and being killed. Now, that's not proportionality, that's intentional, that's a war crime. And you're absolutely right, it is used as a mechanism to terrorize, because they don't want the people back. This is how they think that they could take over the land. It is to terrorize people to the point where they don't want to come back.
Exactly.
So there's the mental warfare as well as the physical, and also the destruction of the land. And worse,
Yeah.
and worse, in Lebanon, they want a civil war. They love the idea of creating a civil war. So they will create tension between the different groups of people. They haven't succeeded, and we'll wait and see what happens on that front.
Yeah.